Hi, welcome to the exam tip. Today I'll be covering offer and acceptance from your contractor syllabus. When you're finding a question on offer and acceptance in your exam paper, if you know the process as to how to approach the question, you get a good marks from the area. So when you're finding a question from offer and acceptance in the exam paper, the first thing that you do is you find out the statement that you think that it might be an invitation to treat or an offer for that purpose. You tell the examiner as to why it might not be an ITT. You tell him the general principle, you tell him the exception. Then you move on to saying that why you are thinking it might be an offer. Give reason. Then you tell the examiner as to whether it might be a bilateral offer or it might be a unilateral offer. In the exam paper, it's more likely that you'll find question from the area of unilateral offer. So you need to discuss the principle of Carlyle versus Carvalho against Smallwood very well. After having done so, you move on to the second aspect. That is communication of offer. For there to be a contract, the offer would have to be validly communicated to the offeree, because otherwise the offeree cannot accept the offer and there will not be a contract in the first place. So knowledge of the offeree, of the terms of the offer, is vitally important. You go through the facts and try to find out whether or not there is any issue respecting the knowledge of the offeree, because if there is an issue respecting this knowledge thing, you need to discuss that with reference to case laws. Then, thirdly, you move on to the aspect of acceptance. So if the offer has been made and is being validly communicated with the offeree, then the issue of acceptance comes. What is an acceptance? You know that it's an unqualified expression of assent to the terms proposed by the offeror. So if you find from the factual scenario that the offeree is doing something like that with reference to case law, then you can argue that it might be an acceptance. Over here, you need to thoroughly look into the facts as to whether or not the offeree has been trying to negotiate any term of the offer, because if he does so, in that case it might be a counteroffer which will in essence kill the original offer. So if you assume that the offeree has accepted the offer in the manner of the principles, you move on to the fourth aspect, that is communication of acceptance, which is very important, by the way. The offer would have to be validly communicated. Likewise, the acceptance would have to be validly communicated with the offeror. If the acceptance is not validly communicated with the offeror, in that case, the acceptance is not valid in the eye of law. Over here, you need to go through two vital aspects. One being the postal rule, the other being communication respecting instantaneous modes, that is, emails, fax, telephones, mobiles, etc. You know about the postal rule. It's a very straightforward rule, as given the case of Adam versus Linsell. Over there, it was stated that when the letter of acceptance is posted, acceptance takes place. But you need to understand that there are exceptions to the postal rule, but the general rule is very strict and in practice is being very rigidly applied. Then you need to know about the instantaneous communication, which is very important for the purpose of your exam. Two cases are vitally important: Enters versus Miles Far East Corporation and Brinkybone versus Stark Stall. In these cases, the principles that we have got is acceptance takes place respecting instantaneous modes of communication when it is being received by the offeror where he happens to be. So two things are important. Number one, the offeror would have to receive it. Number two, where he happens to be. So if I am about to be in my office and I have given my email address in the advertisement where I have put my offer, and if the offeree sends an email accepting my offer during the office hours, when it is being sent, it's being received by me, right? Because it's instantaneous communication. So then and there, the contract has been formed. The acceptance has taken place, whether or not I have read it. So the principle is very straightforward, but we need to look into the principle in details and discuss the principles in details in the exam hall. This is very important for the purpose of the exam. Finally, the aspect of revocation is very important. Was that revocation of offer? The offeror can terminate the offer at any time before it is accepted. But this principle is a bit different when we are talking about unilateral offer, because over there, the case of Errington has stated that if performance has started, the unilateral offer can't be revoked. Okay? So we would have to look into the factual aspect to understand whether or not there is any issue respecting Errington. There is another principle which is very important, that is Shu versus USA, which has stated that the unilateral offer would have to be revoked in the same manner in which the offer has been put forward. So if I have given an offer to the world at large by publishing a newspaper advertisement, I would have to revoke the advertisement before performance is started by giving the revocation publication in a newspaper. So that's all. So when you are dealing with an offer and acceptance question in the exam paper, you go through these 5 phases, 5 stages, and hopefully you discuss these 5 aspects very well. Hopefully you'd get a good mark. So the first thing is consider the statement. The second thing is the communication of offer. Third thing is acceptance. The fourth thing is communication of acceptance. And lastly, revocation of the offer. Good luck for the exam.